Today we're going to talk about physical commencement of development consents in New South Wales, why it's important, what it is, and how you might be sure that the development consent that you have is operative and has been commenced. My name is Mark Evans from Whiteacre Legal. I've been providing planning law advice and property law advice for the last 20 years or so, and today we're going to talk about physical commencement of development consents. What is physical commencement? Well, it's not actually defined. There's no definition of physical commencement in the legislation, but it derives from section 4.53 of the Environmental Planning and Assessment Act 1979, which says that a development consent doesn't lapse if building, engineering or construction work in relation to that development consent has been carried out on the land to which the development consent relates. So why is it important? Well, development consents usually have a lapsing date of 5 years from the date that they are determined or granted. So development consents expire or lapse. And they don't lapse, or the development consent does not lapse, if building, engineering or construction work is physically carried out on the land to which the development consent relates. So it's obviously important. Physical commencement of the development consent is obviously important because development consents can be very valuable. Often people don't want them to expire or lapse, and so they can be very concerned to make sure that the development consent is valid and remains operative. So that's what physical commencement broadly is. What are the key requirements for physical commencement? The seminal case in this area is a case called Hunter Developments versus Cessnock City Council. That's a 2005 Court of Appeal decision, and from Hunter Developments we can pull out some of the key principles of physical commencement. The first of those derives from the legislation, section 4.53 itself, and that is that the works must be building, engineering or construction works, and those works that are relied upon must relate to the development consent. So if those works have been carried out somewhere else or they've been carried out for some other reason on the land, then it can't really be said that those works relate to the development consent. They must have some nexus or connection to the development consent. So that's the first principle that we can pull out from Hunter Developments. The second principle is that the works actually need to be physical works. It's physical commencement, so the works need to be physical works. They can't just be theoretical or office work. And the works that are sought to be relied upon need to be carried out on the land to which the development consent relates. So the development consent will be tied with the land, and those works need to be physically carried out on the land to which that development consent relates. The third principle is that the works must be lawful, so they must have been carried out lawfully, and I'll come back to that point in a moment. And obviously the works need to have been carried out before the consent lapsed. I'll add in another principle here, and that is from Hunter Development, that the works need to be more than merely a sham, quote unquote a sham. So that is, as it sounds, the works that are sought to be relied upon must be more than sort of a token effort, driving a single survey peg into the ground on the site. It's probably not going to be enough to get you there. So the works need to be, I think, a genuine attempt or carried out in a genuine way to commence the development consent. Now that we've covered those principles, let's talk about some of the works that have been relied upon in the past in case law to constitute physical commencement of a development consent. Probably the first of those, as I mentioned before, are survey works, so the placement of pegs, pegging out a site, the placing of survey pegs in the ground to mark out a site in combination with other things. So the placing of survey pegs. Another one that has been relied upon in the past in case law are ancillary works, so clearing of trees and shrubbery and those types of things, provided that they're lawful, has been held to constitute physical commencement. And another big one is geotechnical work, physical geotechnical work. So the drilling of boreholes, soil samples, the taking of those samples for laboratory work, etc., has been held in the past sufficient to constitute physical commencement. But, and there's always a big caveat to that, following the introduction of Section 96 of the Environmental Planning and Assessment Regulation 2021, the regulation, following the introduction of Section 96, the test for physical commencement has become a lot harder. And a lot of those works that I just mentioned by themselves today will not be sufficient to constitute physical commencement. So Section 96 of the regulation was brought in as a result of that previous case law, the previous cases about those works, and specifically Section 96 specifically says you can't rely on one or more of these by themselves to constitute physical commencement. So you can't rely upon the placing of survey pegs by themselves. You can't rely upon borehole testing and so on by itself to constitute physical commencement. Now that doesn't mean that you can't still rely on those works together with other works to constitute physical commencement. Just by themselves, they're not going to be enough. So the ground has shifted and the test has become a lot harder following the introduction of Section 96 of the regulation. The works that are sought to be relied upon need to be lawful. So often that involves reading the development consent really carefully and making sure that the works that are sought to be relied upon can be carried out lawfully, that they don't breach the development consent itself. Now, commonly, as you probably know, the development consent will set out and have conditions in there. One of those conditions will say you need a construction certificate before you can carry out any works, or sometimes they'll say you need a construction certificate before you can carry out any construction works. So we need to consider that, or those conditions, really carefully and make sure that a construction certificate wasn't required before the works were carried out. Now, we all know typically a construction certificate is not required to do borehole testing, or it's not required to do setup works on the site, but you just need to be really careful to make sure that the development consent or a condition of the development consent has not been contravened by the works, because if the works are found to be unlawful, well then obviously you can't rely on them to satisfy physical commencement. So we've covered what physical commencement means. And we've covered some of the works that may be relied upon to satisfy or to constitute physical commencement. And we've also covered the recent introduction of Section 96 of the regulation, which makes the test a lot harder. I'll talk now about typically what happens for clients who may have a development consent that they're worried about lapsing. Typically, they will come to me for advice, and they'll have a list of works that they've carried out in the past, and they'll be wondering whether those works might be sufficient to satisfy the test for physical commencement. It's really hard just to look at one or two things and tick the box and say, yes, you've definitely activated the consent. But typically the process that we go through is we have a look at the works that are being carried out. We have a look at the evidence for those works, so things like invoices and reports and things. And then we also have a look at the development consent and the conditions of that consent to make sure that the works themselves are lawful. And we give advice and assistance about whether, in our view, the development consent has lapsed or whether it has been physically commenced. Sometimes we can write to the consent authority, typically a council, and we can give them an advice that in our view, based on the case law, the development consent has been physically commenced and is operative. And a lot of councils will actually write back and tell you that yes, they agree with that, and in their view the development consent is active and it hasn't lapsed. Other councils won't do that. They'll just say you need to go off and get your own legal advice, or we're not going to make any comment on that. But most councils are pretty good, and they'll confirm whether in their view they think the development consent is still active or not. If you have a development consent and you're worried about that development consent lapsing, we strongly encourage you to get competent planning law advice. Each case is different, and you need to get competent legal advice that's specifically tailored to your individual case and your needs. My name is Mark Evans from Whiteacre Legal. If you found this video helpful in any way, or even slightly or mildly entertaining, please hit the like and subscribe button. There's heaps of other articles and videos at our website, www.whiteacre.com.au. You can visit that website and check out some of those articles on other planning law topics there. All right, thanks for watching.